Okay, great. Good afternoon, everybody, and thank you for joining us tonight. We are looking forward to having this very timely discussion with Professor Maryam Ahranjani, who we are so delighted to be joining us tonight. Before we get started, a little bit of background about the Iranian American Bar Association. IABA's mission is to educate the community about legal issues of interest to Iranian Americans, protect and advance the rights of Iranian Americans and other minority groups, promote and foster the achievements of Iranian American legal professionals, and fundraise for law student scholarships. This year, the IABA DC chapter is putting on a series of legal education webinars and in-person meetups, so please make sure you follow us on social media so you stay engaged and you know when our events are happening. Before we dive into our presentation, I have a few housekeeping remarks to ensure that we have a smooth and productive experience tonight. First, we do have a Q&A session, so please keep your audio muted for the duration of the webinar and go ahead and submit your questions throughout the discussion. I will be able to see what you pose and I'll make sure that those questions are raised. Please note that the webinar is being recorded, and I want to emphasize that what we discuss tonight is for educational purposes only and does not constitute legal advice. If anybody who's in attendance has any specific legal questions, we strongly encourage you to consult with a qualified attorney. And additionally, to the extent that there are any opinions that are expressed tonight, they are the views of the speaker themselves and not IABA DC. If there are any types of supplemental materials or anything like that, we will make sure to follow up after the presentation. We don't anticipate doing that for this discussion, but if anybody has any follow-up questions, please feel free to reach out to us. Now, without further ado, it is my honor to introduce our distinguished speaker tonight. Professor Maryam Ahranjani teaches, writes, and speaks in the areas of constitutional rights, criminal law and procedure, and educational law. She's fluent in Spanish and Persian, and she has domestic and international professional experience, which includes working for a boutique education law firm in DC, the National Association of College and University Attorneys, the U.S. Department of Education, the U.S. Department of State, U.S. Agency for International Development, the ABA Rule of Law Initiative, and law schools in Latin America and Spain. Previously a professor of law at the University of New Mexico School of Law, she joined the Boyd Law faculty in 2025. Thank you, Professor Ahranjani, for joining us tonight.
Thank you so much, Shirin Jun. I am truly honored to have been invited to share this line of my research with all of you about school policing. And I want to emphasize that similarly, I'm speaking in my personal capacity with you all and not on behalf of my employer, the University of Nevada, Las Vegas, and really for educational purposes, not for the purpose of providing legal advice. And let me also offer deep gratitude to Nikki and Shirin, of course, and Yalda for their hard work to make this event happen. Your organizational skills are second to none. I've been really impressed. I'll just start by sharing that there's a common refrain among academics that often research starts with me search, whether we admit it or not. And with regard to school safety, I can share that my own experience as a child of having a mass shooting at my elementary school inspired my own decades-long interest in this topic, as well as some professional experience, which I'll talk about later with the Marshall Brennan Constitutional Literacy Project. Now, unfortunately, this experience of school violence has been more common over the past 30 years or so, although maybe not quite as common as we might think, due to a number of factors that elevate the relatively small number of mass violence incidents that do happen in America's schools every year. But this is not surprising. The presence of the reality of these incidents, given the confluence of relatively easy access to guns in the United States, emotional isolation experienced by many young people, and even older people, of course, and just really inadequate supports for that isolation. And unfortunately, as I've written, our main response has been to quote unquote prisonize schools, or make schools feel more, look like more, and act more like prisons. And Texas is a good example of this, although it's not alone. But after the horrific shooting at Uvalde Elementary School in 2022, the state has spent billions of dollars to station police officers in all public schools across the state. And, very quickly there were reports of harsh and abusive treatment of children. And in fact, in recent reporting by the New York Times and a local paper in Texas, they revealed that elementary school children, including one as young as 6 years old, have been handcuffed in school. Children have been arrested, charged with crimes, and even jailed. And in extreme cases, they have even ended up in hospitals, bruised or concussed, after being body slammed or shocked by tasers, which are prohibited in the state's detention facilities for children, but are currently allowed in their public schools. So we have a few videos to frame the importance of this topic and just give you some examples of what's happening. Again, not only in Texas, but this reporting just happened, was published a couple of months ago by the New York Times. So maybe we can, Nikki, John, if we could show the videos, that would be great.
While Nikki is pulling up the video, I do want to ask you, what do you think is the cause of this dichotomy of, for example, officers being able to use tasers or school resource officers, whatever the title may be, tasers and those types of things in schools when those types of weapons are not able to be used outside of the schools and in the juvenile detention centers, as you mentioned?
Yeah, I wouldn't want to speculate for this exact situation because I don't know the answer to that question. But I would say, a lot of times when we pass legislation, we're not, unfortunately, especially at the state level, there isn't as much attention to sort of aligning, language and requirements across different sectors and across different pieces of legislation as just as a matter of sort of general practice as much as people might think. And so it may be just due to that, but and I hope that this reporting, I think that it will, and probably already has shined a light on the this practice. And so hopefully there will be, a reaction as a result. But I do think, it is also possible that it reflects a very strong impulse that we have in the United States to implement knee-jerk reactions in legislation that are often overshooting without thoughtful deliberation about the consequences, unintended consequences of our legislation. So those could be some reasons.
Looks like Nikki has pulled up the video.
Yeah, great. So the video that you're watching right now is actually uh, a, a boy who threw a punch during a fight in the cafeteria at lunch, and a school. Oh, I'm sorry, that's a different video. This one, this with the student being slammed against the lockers, was a 14-year-old boy who was caught with a vape at his school in Mesquite, Texas. And after he was restrained, he was smashed into a wall by an officer. And the officer reportedly shouted, and you can see this in the video, "Who else?" To the teenagers that were gathered nearby. Um, so if anyone's interested, you can just Google this New York Times and Texas school policing. You'll find the article, and you'll find actually there are multiple pieces and more video that was released highlighting the challenges here with having police officers in public schools. Now, many people would say, there are good reasons to have officers in some schools at some times. But I think what we've done by and large is overuse that role to really address issues that are fundamentally about um, not about violence, but about students not feeling like they or not having the resources to be successful, whether it's health or mental health or other things they need to be successful at school, including honestly shelter at night and food and adequate sort of basic life needs.
I want to turn to your work in this space a little bit, specifically the paper that you had written from Unresting School Safety, which builds on your previous work. If you wouldn't mind, speaking to our audience a little bit about how you started to work on the paper, what you were specifically looking at, and what really inspires you to continue writing in this area, which is candidly very difficult. I mean, we can see from the video, this is a very difficult area of the law.
It is. So I mentioned earlier my work with a program called the Marshall Brennan Constitutional Literacy Project, which was started in 1999 by now Congressman Jamie Raskin and now retired Professor Steve Wormiel at American University, where I was a law student, and I served as one of the first teaching fellows in the program. And and over the years, I've been involved in the program in different ways, including developing curriculum, running the national organization, and now as a full-time tenured faculty member, running chapters at the University of New Mexico and now at Boyd Law in Las Vegas. And what I've seen in my experience over time and in different school districts across the United States is just this, again, like very rapid expansion of the use of police in public schools to try to address this sense of safety that we all want our children to feel, and we all want to feel, in public schools. That unfortunately there's a mismatch, though, is what I've argued and investigated and written about. So in prisonization, I was really describing what I was seeing in the public schools, which was this increase in metal detectors, in drug sniffing dogs, and police on campuses. And initially, it was really on campuses that were primarily urban and primarily populated with a certain demographic of student, usually students who were in modest families, income-wise, and who are the members of racial minority groups, either Black or brown children. Now that the use of all these what I call prisonization practices in that article has expanded to include other schools as well. But unfortunately, the problem has only expanded. It hasn't decreased. And so I've continued to work on trying to make some analysis and arguments around the constitutionality of this particular intervention of school police, but also more broadly, prisonization practices. So after prisonization, I continued to explore what I call the constitutional harms associated with school police, including, for example, the First Amendment right to freedom of speech, the Eighth Amendment's ban on cruel and unusual punishment in public schools, what I argue should be an Eighth Amendment ban on corporal punishment in public schools, freedom from unreasonable search and seizure protected by the Fourth Amendment, due process, particularly procedural due process, and equal protection, among other potential constitutional implications. So this latest piece really focused on an intervention to fill the gap that would be created by a reduction in school police by people who are trained experts in the kinds of things that really do lead to school violence. And those people are school psychologists.
You mentioned in the paper that the Supreme Court's rule in Ingram versus Wright, which is the 1977 decision relating to the Eighth Amendment's ban on cruel and unusual punishment, doesn't apply to schools because schools aren't prisons, despite the fact that schools seem to have, especially a lot of modern public schools, a lot of the same feeling and operational standards in place that would translate very closely to what's happening in prisons. Can you elaborate on that a little bit?
Yes, absolutely. In fact, the reason I called the practice prisonization is really to emphasize that point that the court in Wright made, which was that, that the Eighth Amendment had and the Cruel and Unusual Punishment Clause had previously has really been applied in prison and prison-like circumstances. So based on what I was seeing across the country in my role with the Marshall Brennan Project, I was seeing that they look, feel, and operate just like carceral facilities, such that we should reconsider that holding. And so I've made that argument in numerous spaces. Um, uh, what else did I want to say about that? Well, and so there's another piece in case anyone's reading and interested. There's another piece I wrote in the South Carolina Law Review about 15 years ago now, looking at corporal punishment in schools, in society at large, by the way, and in schools. And I did some research on what happens in other countries and what doesn't happen in other countries, to just sort of compare and contrast what we've allowed in the United States in terms of the use of force against young people in public schools.
And based on your analysis of how the US kind of measures up compared to those other countries, what are you seeing statistically?
Well, so I mean, our peer nations um, tend to ban the use of corporal punishment, even in family life, even in private life, and certainly in public schools. So now we are, and that doesn't necessarily convince anyone, frankly, as we know. The Supreme Court isn't so interested in international law, generally speaking, although there are some notable exceptions to that, especially in the area of juvenile law. But I would say well, another interesting finding was that the psychological research on the harms of corporal punishment is interesting and surprised me in ways that sort of explain why corporal punishment is still legal in a number of states in the United States. It's just under 20, I believe, at this point. States do allow corporal punishment in public schools. And they're primarily states in the South where corporal punishment is also widely used in private settings. And according to some of the research I found, it's not as harmful when it's sort of commonplace practice, as opposed to if a child lives in a community where no one else is being physically punished for misbehavior, and then they receive physical punishment that has a much greater impact on them, negative impact on them. So I think that international research is important to look at, but I think it's a little more nuanced than just, oh, other countries don't do it, why are we doing it?
In your research, looking at how corporal punishment is still legal in the countries that, or I'm sorry, in the states in the South that you mentioned, do you see a correlation, for example, between states that allow corporal punishment in schools and, higher test scores, for example, or lower instances of violence in schools? Are you seeing any type of direct correlation that would suggest it's better to allow corporal punishment in schools versus not?
That's a great question. I haven't specifically tried to isolate whether there's a link between corporal punishment and educational outcomes. I mean, frankly, I'd be surprised if there's a positive um, correlation there. I think anyone who's been around children knows that you know um, physical punishment generally doesn't improve behavior or outcomes. But yeah, that would be interesting to look at.
What about for instances where the children who are impacted are children with disabilities? Have you seen in your research that children with disabilities are impacted at a higher level in schools that do allow corporal punishment or this uh, you know, prisonization of the school system?
Mm, very good question. And I mean, let me just step back and frame a little bit for your listeners what we're talking about when we talk about students with disabilities and in education. So just high level overview, there are really three federal laws today that offer protection for students on the basis of a disability. And so that's Section 504 of the Rehabilitation Act from 1973. The Individuals with Disabilities in Education Act, or IDEA, which was first passed as the Education for Handicapped Children Act in 1975. And then finally, the Americans with Disabilities Act of 1990. So Section 504 makes it illegal for federal agencies, public universities, and other public institutions that receive federal funds to discriminate on the basis of disability. And then the EHCA, which was later reauthorized as IDEA, guarantees a free, appropriate public education for all children with disabilities in the least restrictive environment. And then finally, there's the ADA, which was landmark legislation signed into law by President George H.W. Bush, prohibiting the discrimination of people with disabilities in all areas of public life, including jobs, schools, transportation, and public and private spaces open to the general public. So the ADA gives civil rights protections to individuals with disabilities, similar to those provided to individuals on the basis of race, color, sex, national origin, age, and religion in other federal law. So these laws and related regulations, and then some case law, as well as some state law, form the primary basis of legal support for students with disabilities. And there are some instances where state laws can offer additional protections. And of course, particular institutions can choose to exceed the limits of those protections, which maybe I'll have a chance to talk about a little bit later in the conversation in terms of the role of school counsel and advocates. But to answer your precise question in terms of whether students with disabilities, I mean, generally speaking, there is research that shows that students with disabilities and Black children in particular, and other children of color, and boys in particular, seem to be disproportionately disciplined in school, in public schools. And so, and that's in many different ways: suspension, expulsion, harsh punishments like restraint and seclusion. And that treatment leads to thousands of incidents each year in which students are seriously injured, and even there are deaths every year related to the harsh punishments of children in our public schools. So I don't have the exact numbers for you or the exact, what sort of state by state breakdown of that, but I'm happy to provide resources to anyone who's interested in learning more.
Thank you for that. I do want to shift now to the critical role of school psychologists.
Sure.
So you mentioned what role psychologists can play in this overall paradigm. Can you elaborate on how you view school psychologists in this system that we've been talking about?
Sure. And I'd love to talk about the way in which I became familiar with the potential role, and the current and potential role of school psychologists was that, after George Floyd was murdered in 2020, of course, there were efforts to defund or reduce funding for police, including police in schools across the country. And in New Mexico, where I was living at the time in 2020, I was part of a group that coalesced around the possibility of advocating for a reduction of school police. And a professor at the New Mexico State University, who's a school psychologist, and she runs their graduate program in school psychology, named Dr. Peterson, reached out to me and said, hey, I'm a school psychologist and I really care about the harmful effects that school police may have on children in schools, and I'd love to collaborate. So over a number of years, we sort of stayed in touch. We interacted with one another. I got to know her students. I spoke to her students. She invited me to participate in the statewide school training for school psychologists that they have every year, and to talk about their ethical obligations around school policing. So that's how I became really familiar about these very robust ethical obligations of school psychologists, both to interrupt the harmful effects of policing for an individual child who they may be working with, and also to the extent that they notice that there's a system or systematic harm or harms being caused to children, that they also have an obligation to try to interrupt that or those practices. So that's how I really became familiar with it. And then I started digging into the voluminous amounts of legislation proposed and a smaller number that actually gets adopted in recent years around school safety. And there's an increasing role for school psychologists in that legislation. And so that's how I started to think about the role of school psychologists. I'll add one more factor that contributed to this. There was a landmark case in New Mexico in 2018 called the Yazzie Martinez decision, in which a district court judge, Sarah Singleton, found that the state of New Mexico was not meeting its obligations under the state education clause for a number of different groups of students that totaled about 75% of the population of school-age children in New Mexico. And so she found that there was inadequate funding, the outcomes were insufficient, and many other things, problems that she found with the system. So since 2018, the state of New Mexico has been working hard to try to improve outcomes for children. And one of those huge problems that was identified by Judge Singleton was the very high ratios of school social workers, school counselors, and school psychologists in the state. And then so I was following and, of course, involved, sort of indirectly in the work of that case and trying and compliance with that case. There was one school district I was working with very closely to try to help, sort of comply with the goals of the case. And we just realized that there are a lot of reasons why there aren't enough school psychologists, but it's very clear that that's such an important pivot point to interrupting violence in schools.
When you were working on the research specific to the psychologists and speaking with them and trying to get the underlying information relating to how they can provide this pivotal and critical role, were they providing information about how they felt like their ethical obligations might be pulling them in a different way than where the school system might be going?
Absolutely. It's what I learned, and this is, in the interest of like honesty here, academics I can sit in my office and say lots of things, and I'm not on the ground actually doing the work that I think should be done in many instances. And so what I learned from the 100+ school psychologists who were involved in the training that I did was that it's especially in rural settings. I think it's true also in urban settings, but especially in rural settings. There's a lot of isolation of everyone, not just like the average person, but even the school psychologist can feel, overwhelmed by those ratios that I mentioned, oftentimes 2 or 3 times the number of cases and students that they're interacting with than is recommended by the National Association of School Psychologists and others. And so it's easy to say they should interrupt these systems, but it's much harder from what they were telling me than it seems, because they were worried about losing their jobs if they said to the principal, we think the police officer stationed in our school, and you're right that usually they're called SROs, but there are different ways in which they get, they become certified to be in schools. Anyway, so I use the term school police to be a catch-all phrase. And SROs are the major kind of school police, but not the only type. And so, I mean, what I learned from them was really that it takes a lot of bravery. It takes a willingness to, they also don't have the time. I mean, they just have, demands on their time already that they can't meet the obligations of their day-to-day work. And so it's not easy to do this. I know that. But what I also learned from them was they really weren't so familiar with these particular ethical obligations. So just even having the conversation and knowing that they were in solidarity with others in terms of what they were seeing in their schools, I think may empower some to feel like they can speak out in ways that they maybe didn't before they became more familiar with the obligations.
So you highlighted that a lot of them didn't know what their ethical obligations were, and in your papers you've highlighted standard 1.2 of the school psychology ethical guidelines, which just to give our viewers a little bit of insight, it focuses on promoting systems change. And you argue that this creates an affirmative enforceable obligation for these professionals to speak out and disrupt the harmful discipline systems. But what does that really look like in practice? How can the psychologists sound the warning bell when they see students being harmed or disciplined by SROs, or if there are any zero tolerance policies that the school has implemented?
Yes, and we didn't even talk about the like zero tolerance and how that interacts with students with disabilities. But if we have a time later, maybe we can talk about that. But promoting systems change is an ethical obligation of school psychologists. And when I was able, this is interesting. I mean, they have these ethical obligations, and the National Association of School Psychologists and ASP, which has state affiliates in every state. Um, has issued a resolution demanding that they or affirming their anti-racism values and anti-ableism values. There's a 2022 statement that they issued, resolution that they issued, and so I think all of this change takes time, and awareness takes time sometimes. But what it would look like is pretty simple. It would look like a psychologist reporting their concerns if they see, wow, this police officer is slamming kids into lockers when they were accused of having a vape. Like, is that an appropriate response? And they've seen it happen more than once, let's say, something like that. Well, that the simple thing to do would be to go up their chain of command. Often they report directly to their principal, and to let them know their concerns. Now, I have heard from school psychologists that some principals just also are overwhelmed, or frankly don't know what to do about student behavior that is challenging themselves, and so they may say, well, that sucks, but there's not much I can do about it, or okay, I'll try to do something about it, and then other priorities take over. So there's a potential that they would elevate their concerns, and there won't be a response that is adequate to meet the concerns. But I think this is where, like, community members, parents, we're all stakeholders in public schools, whether we have children in public schools or not. I mean, our tax dollars are supporting public schools. So I always encourage people to go to school board meetings, to reach out to school board members and let them know about their concerns that they're hearing about what's happening in their local schools.
That's a great point, and how the community can come together. I want to go back to what you mentioned regarding zero tolerance in students with disabilities. So let's maybe start with what you mean when you say zero tolerance, and then address how zero tolerance policies can impact students with disabilities.
Sure. So, broadly speaking, I think zero tolerance policies became more popular sort of in the 90s, and we're somewhat understanding that it doesn't work, and so they're less common today than they were at one point. But rigid policies that say, if you create any image, for example, of let's say a weapon, that you are immediately going to be suspended from school, right? When there are different reasons why a student might be doing that. That's one common example, that a student will draw a gun, let's say, and then receive harsh punishment as a result of that, without trying to figure out why did they do that, what was it about, what was really underlying that decision. And taking into account also age and brain development and all sorts of factors, the proximity to weapons in particular communities, et cetera. So anyway, I would say generally we're seeing less zero tolerance policies, but we do know that harsh discipline, immediate police intervention. We know from federal data that those kinds of policies do have a disproportionate impact on racial minorities and on students with disabilities, in a way that may bypass or undermine civil rights protections in the laws that I mentioned and other laws. Because we do know that Black and brown students with disabilities face significantly higher rates of suspension, expulsion, and school-based arrests. So, you know, both IDEA and Section 504 of the Rehab Act are supposed to shield students with disabilities from exclusionary or overly punitive discipline. And there's a process called a manifestation determination review that may apply. It's a legal meeting required under federal law that's triggered when a student faces severe disciplinary action, such as expulsion or a suspension lasting longer than 10 days, or where there's a pattern of exclusion that adds up to 10 days or more. And so those reviews are designed to, again, required by federal law, are designed to identify whether the behavior of the child in question was caused by or had a direct or substantial relationship to the student's disability, and whether the behavior was a direct result of the school's failure to properly implement a student's individualized education program. So depending on the answers to those questions, there may be an adjustment to a potentially harsh punishment to students, including students with disabilities.
Are you aware of if students with disabilities oftentimes have to go through a more formal appeal process for the steps that you mentioned, or if there's data that kind of captures maybe the barriers to the steps that they can pursue to maybe challenge a suspension or challenge some kind of disciplinary action that's been taken against them?
So I know from special ed lawyers that there are significant barriers. I don't know of I'd be surprised if there's data collected on that, but there may be that I'm not familiar with. But I do know from speaking with special ed lawyers in different jurisdictions that it's an uphill battle. I mean, it really is for a lot of reasons, right? Just depending on the child's needs, just the day-to-day survival, of a family and of the caretakers of the child can be overwhelming. And so then having to advocate and persistently advocate and advocate, for adjustments frequently is just overwhelming. And so thankfully, I think over time, and this is true of the disability rights movement more generally, that it didn't happen overnight, that those three protections I mentioned under federal law came into being. It's taken a lot of time, decades of organizing. And I think, today we have not just parents, but organizations that are focused, including of parents, but others as well, on advocating for more immediate, I guess, responses by school systems to address the needs of children with disabilities and diverse children with disabilities.
A good segue, since we are, after all, the Bar Association, and we have a lot of advocates among us. So this is a two-part question. First, since the discussion here has been touching on a little bit about what can be done from the outside of the school system, and then also what is being done in the school system to address these problems. What do you think school district general counsel or county general counsel, depending on how the public school system is set up and how the state kind of provides attorneys for the schools that may be facing any type of legal challenge from parents or community members, how do you think those lawyers can better advocate to move away from too many policing policies? And then the second part of that is on the flip side, for advocates that are working with parents or students with disabilities or students who have been disciplined disproportionately to what the cause of the discipline was, how can the advocate's role also be reconciled with what they need to be pushing for on both sides?
Sure. I mean, I think the most important thing to remember, because these battles can become contentious, is I think that we all have the same goal, which is to, produce the most well-adjusted, well-educated, healthy young people that we can. I mean, that is good for everybody, right? Not only our own children and family members, but society at large benefits from the most self-actualized learners. So I think we always have to remember that and try to bring it back to that. shared goal, shared vision. But in particular, with regard to district council, the National School Boards Association provides training to school boards, and there's support for school council, whether they're in-house or outside council. And they certainly train everybody on risk mitigation, but they also talk about the difference between law and policy, and the fact that just because laws provide minimal protections doesn't mean that the protections have to stop there. So they can provide, they can say, listen, all you have, for example, in-house counsel could say, district council could say, well, for this particular type of manifestation of this particular disability, this is all we're required to do as a school system. But we also know that that may not be that we have other resources in place. We may be able to do more for these children. So that's up to the school leaders to make the policy decisions that may exceed what the law requires. And I've talked to numerous school lawyers over time in different places, and just like, if you think about it, if you're interested in impacting the work of police in our communities in a way that's positive and going beyond what's required by constitutional protections, you may consider being in-house counsel for police and providing training and sort of again, an appeal to shared vision, shared goals for our society, that can be really powerful. And you may even have more power inside than you do on the outside, because you can really get to know people. People learn to trust you, and they are willing to experiment with the advice that you give them as in-house counsel for a district, or again, outside counsel for a district. The challenge with outside counsel, though, I'll just say, is that often what I've seen and heard is that often superintendents are reluctant to reach out because of the costs involved, right? They don't have retainer, or they may have like low retainer agreements, and then they have to pay for additional advice. So, and again, it's time consuming, et cetera. So in-house counsel obviously has, I think, a little bit more easy access to conducting trainings and interventions that may not be required by law, but certainly are in the best interests of children and the system at large. With regard to your second question about education advocates and what families, and advocates for families can learn, I would say, this is true of any kind of advocacy. Figuring out where the power lies and how to influence those places of power is really important. I always tell my students who are really interested in creating more equitable education systems, first think about being in-house counsel. That's, again, a place where you can have more power. Just like as a prosecutor, you can have more power sometimes than you can as a defense attorney in terms of systems reform and decision making. But also that, it's important as an advocate to be persistent, to reach out for resources. And sometimes that all aligns with figuring out who the power is. And in the context of public schools in the United States, school boards are the most powerful actors. And interestingly, though, I think many people don't even follow school board elections. They don't know who's running. They don't know what their interests might be. They don't know what their experience in education might be. And so I encourage people to run for school boards themselves if they're interested in reform in their local districts, but certainly to become very well acquainted with the current members and to be active in school board meetings. Oftentimes people don't, there aren't even a lot of attendees at school board meetings where they're making these decisions about whether to sign an MOU with a local police department or not. The boundaries of what the role of the school police can be, et cetera.
Thank you for those answers. I want to turn back to where we started this conversation about how, unfortunately, a lot of what we're seeing in terms of school policing is happening in reaction to unfortunate situations like gun violence in schools and other situations that are truly putting the safety of school employees, teachers, students, everyone at risk. Do you have any thoughts on whether overall these policies of school policing and how discipline is being doled out is really more reactive than forward looking in terms of how the discipline is going to be for the betterment of the student in question, or whether the student has a disability or not. But it could be, as we saw in the video, a student who had a vape that was against school policy.
Mm-hmm. Mm-hmm. Yeah, I think well, first I want to share that the Congress asked the DOJ to do a comprehensive meta-analysis of the research on school policing. And in 2022, the National Institute of Justice within DOJ issued a report called School Policing Programs, Where We Have Been and Where We Need to Go Next. And it just, it's a long report, but I just want to give you this summary that the DOJ, right, that came up with, which is that an examination of systematic reviews and quasi-experiments of school policing, along with expert panel opinions, reveals that the research to date does not support school policing as an effective strategy in increasing safety and security, and that school policing is correlated with some harmful effects, such as increased exclusionary punishment in schools. So I'm willing to bet, like, most people don't know that. Most
Mm-hmm.
people assume that if you have a police present, that's going to make schools safer. And there may be isolated incidents in which that's true. But just to frame this, let's think about what I'm about to share with you in terms of numbers. So every day in the United States during the school year, about 50 million children, 50 million children attend 94,000 public schools. And in the last 20 to 25 years, there have been approximately 700 serious injuries and deaths caused by school violence in and around public schools. 700 relative to 50 million children who attend 94,000 schools every year. And yet we've invested billions of dollars, billions of dollars, putting police officers in public schools to try to intervene, ostensibly for these mass violence incidents. I don't think anyone would say, yeah, we should have police in schools to deal with students getting into a fight in the cafeteria, or to deal with students vaping. Those are things that happen in schools and any place. Children fight, that happens. And so, having a person who is armed, who has arrest power, and who is trained to see behavior that is negative as crime, rather than as the manifestation of a disability, or just sort of behavior that results from undeveloped brains or developing brains, is problematic.
Those numbers are astonishing to
Yeah.
think about it in that kind of scope.
Yeah.
We have about 5 minutes left, and we have a question from an audience member. Question is, individuals with disabilities are required to leave school after a certain age, which can end education for many of them, as they may not have opportunities to go anywhere else. Can you talk at all about the legality of this issue, and what, if anything, can be done to address the lack of educational opportunities for these individuals?
Sure. This reminds me of a woman I know whose profoundly disabled child, aged out, and it really she has dedicated her life to caring for this child in ways that are visible, if in her demeanor, in her health, etc. And so the lack of continued support is really hard on her. And so that I always think about individual stories as a way to kind of think about the larger picture, because when we know someone who's experienced these things, we tend to be more sensitized to others' experience. Anyway, so there are disability lawyers who can certainly advise people in that position on what resources might exist in a local community, but also what kinds of resources federal programs can offer in terms of ongoing, community centers that have at least some kind of programming. A lot of, local community colleges actually offer the opportunity for, depending on the disability, et cetera, but they may offer programs for people to attend classes and even be degree-seeking students. That again are not necessarily required by law, but they're the result of advocacy, right? They're the result of people, again, going to their elected officials and saying, hey, we've got X number of people in this position. We want to be able to offer greater resources for them, which again benefits everyone. It's not just for that particular individual.
Well, that's great to hear. So I want to be mindful of everyone's time. My last question to you. We have a double-digit attendees, and again, since we're a bar association, most of our attendees are either aspiring attorneys or attorneys of some way. What is one takeaway that you hope we all move away from this discussion about, and hopefully, it's something that we can do to help in either advocacy or policy making or otherwise?
Thanks for asking that question. I mean, there's so many ways to answer it, but I would say, if you care about this issue, and that could be for different reasons, but if you care about this issue, to just get familiar with, I always say start local, like hyper local, like what does your local high school that you're funding through your property taxes, in all likelihood, like what is their policy around school policing? Do they have embedded, what I call embedded school police, people who are like full-time on site at the local high school? And if so, are they releasing, is the school district releasing data about what they're actually spending their time doing? And can you look critically at that data in a way that, the average person can't, to see, okay, are they spending a large percentage of their time on the things that align with their training, or should that funding be used differently to meet the needs of children who have emotional needs that are not being met and could be met through instead another school social worker or psychologist at your local school? So I would say, yeah, that would be my number one thing, is to figure out what's going on in your local school, and then to advocate. Again, the easiest way really is to go to the next school board meeting and just figure out, what's going on at that level in your district.
Wow. Thank you so much for your time. We will all certainly think of ways that we can support the mission and the cause, so to speak. This is such an important area of the law, and it impacts everyone, whether they have children or not, anyone who has in some way, shape, or form touched the public school system. Thank you so much for your commitment to this area, for everything that you have done within this area, all of the research, all of your diligence. And we are truly grateful that you spent time today speaking to us about everything that you've been able to look at, and hopefully will continue to be able to be of some support to you as you move forward with additional research or papers.
Thank you.
Thank you. Nikki, we're going to turn it back over to you.
Thank you all so much for joining, and have a wonderful night. Bye-bye.